In the 1930s, the steel industry was spread throughout several states. One business, called Jones Laughlin Steel Corporation, or Jones for short, was a sprawling company with a large workforce. Jones bought raw materials from Michigan, Minnesota, and West Virginia. Jones then transported those raw materials to its massive iron and steel plant in Pennsylvania, where Jones employed about 10,000 workers. From this central location, Jones shipped almost 75% of its product outside of Pennsylvania. It also had sales offices in 20 U.S. cities. One day, Jones fired a handful of workers who had been active leaders in the local labor union. The labor union then reported the incident to a federal organization called the National Labor Relations Board, which Congress had formed by passing the National Labor Relations Act in 1935. The board filed a complaint against Jones, claiming that Jones wrongfully fired the workers because of their union activities. Jones denied that the firings had anything to do with the union and claimed that the workers were fired because they were bad employees. The board held a hearing and concluded that Jones had discriminated against the workers because of their union membership. The board ordered Jones to give the workers their jobs back and pay them for lost wages. Jones ignored the board's order, and the board petitioned the United States Court of Appeals for the Fifth Circuit to enforce the order. The Fifth Circuit ruled against the board and the workers, holding that labor disputes were governed by state law and outside the scope of federal power. The board petitioned the United States Supreme Court for cert. The Supreme Court agreed to review the case to decide whether the National Labor Relations Act fell within the scope of authority granted to Congress by the Commerce Clause. In a 5-4 decision, the court ruled that Congress does have the constitutional authority to regulate labor disputes that have a close and intimate relationship to interstate commerce. Writing for the court, Chief Justice Hughes reconsidered the court's prior decisions about the limits of Congress's power to regulate interstate commerce. Previously, in cases like United States v. E.C. Knight Company, the court focused on the category of a given activity rather than the impact of the activity on interstate commerce. For instance, in the E.C. Knight case, the court held that manufacturing activities didn't count as commerce. The court reasoned that the Commerce Clause applied only to commerce and not to manufacturing, and so labor disputes fell outside the scope of Congress's Commerce Clause authority. But Hughes rejected this distinction between manufacturing and commerce, finding that the distinction could be maintained only in, quote, an intellectual vacuum, unquote. Instead, Hughes argued that an activity's impact was the relevant consideration. Hughes held that the Commerce Clause authorized Congress to regulate manufacturing activity if the activity had a, quote, close and intimate relation to interstate commerce, unquote. Hughes then applied this new test to Jones's case. Hughes acknowledged that normally manufacturing is a local affair. However, the steel business touched on many states. If Jones's workers chose to go on strike, they could cripple the industry's vast interstate operation. In an industry spread throughout several states, such as the steel industry, a major strike could have devastating consequences for interstate commerce. Therefore, the maintenance of peaceful labor relations was closely and intimately related to interstate commerce. The court ruled that Congress acted within the scope of its Commerce Clause power when it passed the National Labor Relations Act, and that the actions of the board were valid against Jones. The court therefore reversed the judgment of the Fifth Circuit. Justice McReynolds dissented, arguing that Congress's power under the Commerce Clause was more limited than the majority thought. According to McReynolds, Congress had authority to regulate conduct only if the connection between the regulated conduct and interstate commerce was, quote, direct and material, unquote. In McReynolds' view, labor disputes had too small an effect on interstate commerce to come within that definition. The court's opinion in National Labor Relations Board versus Jones Laughlin Steel Corporation is noteworthy because of its broad interpretation of the Commerce Clause. By expanding the definition of what counts as interstate commerce, the Supreme Court gave Congress the ability to regulate more commercial activity than ever before.